is hearsay. It's rank hearsay. That's according to State versus Brown, which is 298 Georgia, 878, 2016 case. I cited in division for paragraph 4 of this motion that I filed on September 15, 2023. So I asked the state, and they're going to alert the court. But you know, if there's an issue with anybody putting in Mr. Winfrey's plea it'll be over objection. But if there is, I don't want Jeffrey Williams' name to be in it. He was not charged. He is not pled. He was not arrested. But there was information that the grand jury through the Cobb County DA's office asserted that Jeffrey Williams is an unindicted co-conspirator. So that was my motion.
Okay, all right, State.
Thank you, Judge. Your Honor, I believe that the case that Mr. Steele cited for the court has to do solely with the state using an indictment of a non-co-defendant person to prove the existence of a gang. The indictment, State v. Brown, involves the state simply taking an indictment in an entirely different case of an alleged gang member who is alleged to be a member of the same gang as Brown, and using the indictment itself alone to prove the existence of a gang. Whereas in our case, the shooting of Lil Wayne's bus is not only alleged to have been done by the criminal street gang member of YSL, that is Jimmy Winfrey. It is also alleged as an overt act in our indictment. Now, what the state does not intend to do, which we believe would comport with the spirit of Brown, is we do not intend to put in the counts to which are not at all referenced, or which Mr. Winfrey, which not only did he not plead to, but they're not referenced in any of the counts that he pled to. And along those lines, the counts to which Mr. Winfrey pled guilty are counts 5 and 7 of indictment 152765 in Cobb County Superior Court. And count 5, Your Honor, of that indictment states as follows. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Jimmy Carlton Winfrey with the offense of violation of the Street Gang Terrorism and Prevention Act, for that the said accused person, on or about the 26th day of April 2015, being associated with the Bloods, a criminal street gang, did unlawfully participate in criminal gang activity through the commission of the offense of violation of the Racketeer Influence and Corrupt Organizations Act as set forth and described in counts 1 through 3 of this indictment, and incorporated herein by reference, contrary to the laws of said state, the good order, peace, and dignity thereof. Similarly, count 7 reads that the grand jurors accuse Jimmy Carlton Winfrey of violating the Street Gang Terrorism and Prevention Act, for that on the 26th day of April, while associated with the criminal street gang, he participated in criminal gang activity through the commission of the offense of criminal damage to property in the first degree as set forth and described in counts 25 through 26 of this indictment, and incorporated herein by reference, contrary to the laws of said state, the good order, peace, and dignity thereof. That said, the state would only be introducing, as part of the certified conviction of Jimmy Winfrey, the indictment portions that reference either counts that he pled to or counts that were incorporated into the counts that he pled to, as indicated in the language itself of the counts. So that would mean counts 1 through 3.
Do any of those counts reference Mr. Williams?
They do reference Mr. Williams, Your Honor, because Mr. Williams, as alleged in this indictment, was a part of the act that Jimmy Winfrey committed when he shot up the bus that was Lil Wayne's tour bus. So, Judge.
Can I see it?
Yes, Judge. And I will give to the court both our certified copy.
And that's already been provided to the defense in this case?
Your Honor,
I have my own.
Okay. All right.
which consists of the original indictment and plea, and then the subsequent indictment and guilty plea, which was entered in 2020. And then we also have a copy of the indictment and counts with the redactions that we intend to include. So the first document that I'm giving to the court, and we would not be admitting the first indictment and guilty plea, we would be entering the second one, which is about makeup of the entire certified.
Okay, so this is the first one, the first copy of the indictment?
If
Oh,
the
is it?
court will allow me to have it back, I'll go ahead
Sure.
and separate it out.
Yes, please.
Your Honor, I'm giving to the court the guilty plea entered in the year of 2020, the most recent guilty plea. And the second set of documents is the guilty plea with the indictment, rather, with the redactions that the state intends to include. And that means redacting count 4, count 6, and all other counts with the exception of counts 25 and 26. So counts 1 through 3, 5, 7, and 25 through 26 are the only ones that the state would intend to utilize. And that is what Mr. Winfrey pled guilty to. That is one of the overt acts alleged in this indictment. And given that Mr. Winfrey is a co-indictee, an accomplice, and an alleged gang member and member of the criminal enterprise that is Young Slime Life, the state's position is that the state is entitled to show that Jimmy Winfrey entered a guilty plea. An Alford plea does not negate the fact that it is a guilty plea to those counts and to those allegations alleged and incorporated in those counts in that indictment.
Let me ask you a question, Ms. Love. Is it your intent to call Mr. Winfrey at some point in time?
Your Honor, our intent is not to call Mr. Winfrey. Our intent is to prove up the case that Mr. Winfrey was to present evidence independent of the indictment itself.
I mean, are you going to put him, or is it your event, are you going to call him during your case in chief?
Mr. Winfrey, no.
Yes,
But
why
we're
not?
gonna, Your Honor, because he is so there are two things. We intend to prove up the case itself. We don't intend to just put in an indictment.
Well, I'm saying if you called Mr. Winfrey and you wanted to, consistent with your case in chief, and for example, asked him questions about his involvement, then certainly I could see how that indictment might then be appropriate to show knowledge or to impeach. But that's why I asked you that question. It wasn't for me. It wasn't for the court asking any other purpose. But
Judge, it'll be similar to the certified copy of the indictments of Shannon Stillwell that we've entered. And Mr. Stillwell, I cannot compel him to testify. It would be similar because Mr. Winfrey is awaiting trial in this case. I cannot compel him to testify in this case. He is, as Mr. Stillwell is.
did he plead? Did he plead, or is he?
He pled guilty to the Cobb County case, not to this case. He is on this indictment.
Is he in the other Splinter case that we have in this case? Is he in?
Yes, he is. I'm sorry. Yes.
Okay, all right. That's what I meant. The other matter that my colleague Judge Dempsey is
Yes.
handling at this point in time. So he's in that case.
Yes.
Okay, I understand. Okay, all right. Okay. It's a certified copy, but that gets you the record. Okay, that gets you the record. Mr. Steele's still got an argument that would be hearsay at that point. Is that correct? Mr. Steele, is that correct?
Of course. It's a self-authenticating document, Your Honor.
That gives that with self-authenticating documents, you still have other bases for objection, meaning that you can get the document in and under the self-authenticating clause, but it's still subject to or provision, but it's still subject to other objection.
So, Your Honor, what we would not be doing is just entering, and that was what I was saying at first. We would never just enter the certified copy of even the conviction without proving up the facts that are alleged within the document itself. So we won't be offering up a certified copy of the conviction.
I'm back. I did see the dog. I took the call from the sauna.
The enterprise and the criminal street gang that is YSL and their association. What we will be doing is putting the case up to the jury that Mr. Winfrey.
I have to get the dog.
We will be putting up the facts of
I don't know if you're still here, AV.
They are alleged overt acts that we have to prove. We cannot just put up the conviction. We will be putting the witnesses up that prove that case.
I understand that, but Mr. Steele's argument.
And we will be putting up the evidence that shows that what is alleged and to the counts that he pled guilty, those.
That's Mr. Winfrey, that is.
Your Honor, we will be showing not only Mr. Winfrey, but the association with various members of YSL that are included within the indictment. In other words, we will be proving up as if we were on trial in that case. We will be proving up the various elements of that case against Mr. Winfrey.
But here's the thing. The indictment references Mr. Williams, who was not on trial for that case.
We will be proving what is alleged in the indictment regarding Mr. Williams as well. We will be proving it with witnesses, not just with that certified document.
My kids are running around upstairs like mad children.
I'm not saying it might not come in, but I don't know if it'll come in at this point in time. But I have some concerns. I understand what you're saying. You're saying, okay, we're going to approve Mr. Winfrey's conduct, okay? And Mr. Winfrey's pled guilty to this indictment, the second indictment anyway, so that certainly would be appropriate. But I think that you would probably have to redact out Mr. Williams' involvement at this point.
So, Your Honor, prior to and without putting up evidence of what Cobb County alleged in that indictment regarding Jeffrey Williams, I would understand that requirement. We intend to put up that information, and it would not be hearsay when the state has proven the allegations that are made in the indictment. And that is what we intend to do. We intend to prove the
But wouldn't it be cumulative at that point of other evidence? I mean, here's the thing. I think that it might come in. It might come in. It really might. But I think it's going to depend upon what is testified to. I mean, I certainly understand with Mr. Winfrey, you could probably use this indictment for whatever he's pled guilty to. And that would not be an issue. But I think Mr. Steele, on behalf of Mr. Williams, is indicating at this point now that he's objecting to it because it certainly would be considered but hearsay. Even though the document itself,
I may have to take the kids to jujitsu soon, but let me see if I can find Zach. I don't know if you're still here, Amy, but
also I could foresee
my dog
depending upon
is,
what
I think, in the next
testified
room,
to, then the
sitting
facts
on
in
his
this
throne.
indictment may become more relevant, meaning that should the door be opened as to things in this particular indictment, then other things might be. Certainly the court would
Let me go check on the
reevaluate at that point in time.
Jiu-Jitsu all.
But I think
I may. I'm gonna.
chief
Well, let's see if we keep
is
it going.
subject to
Now,
some
valid
objections.
if you're just logging in, I'm
That's
probably
just
gonna
what the
go.
court's-
I can leave
the
this
court's
stream
thinking at this
going.
point in time. Mr. Steele, anything else?
Let's see.
Okay. So do you understand why I'm saying at this point in time? If you wish to go ahead and use the indictment, that's fine. I think the redaction would be appropriate, but you'd have to redact out anything involving Mr. Williams at this point. Now, that's subject to if somebody opens the door as to that particular issue, either from any other, from cross-examination by the defendants or in their case in chief, should they decide to present any evidence and not requiring them to do so. But then that would be, certainly the court would relook his position under that particular set of facts.
And so what I think we'll be doing, Your Honor, is not even introducing the exhibit until we...
Your choice, okay? Because here's the thing, even if you introduce the evidence, it's subject to other, it could be, I'm not saying it will be, but it could be subject to other additional objections.
Yes, sir.
Okay? All right, the document itself, but I'll leave you, I'll take it up. At this point in time, I'm inclined to
Your Honor, speaking on tender,
like I said, I'm giving my preliminary thoughts on it, that if you decide to issue it in your case in chief, it would be subject to redaction. So you can use that